SJC-13568, Susan Hartnett, the Contributory Retirement Appeal Board et al.
Okay, Attorney Reynolds.
Thank you, Your Honor. Good morning. Assistant Attorney General Mary Ann Reynolds, representing the Contributory Retirement Appeal Board and the Public Employee Retirement Administration Commission. These agencies, CRAB and PERIC, have been entrusted by the legislature with the administration and implementation of Chapter 32, a notoriously complex statute that applies to over 100 retirement systems, and we urge the court to reverse the judgment of the Superior Court in this case and to enter judgment for the defendants. The Superior Court erred by starting but not ending the analysis under Section 25(5) that this court established back in 1973 with opinion of justices. The core of a member's reasonable expectation is to be honored and has been, but that expectation is subject to reserved police powers. And we argue that the Superior Court erred here by not completing an analysis under the reserved police powers, and that had that analysis been conducted, as is explained in our briefing, that the result should be that the reserved police powers come into play here such that what's called the anti-spiking provision should be applied to Ms. Hartnett. Significantly, Ms. Hartnett does not dispute that the 2011 statutory reforms in the wake of the 2008 nearly unprecedented financial crisis could apply to members. She does not dispute that. What her dispute is that she does not want this one particular provision to apply to her. We say that it should apply to her. And as to why it applies to her, we do feel that here the Superior Court got it right, and we commend to this court's consideration the Superior Court's decision and reasoning with respect to the interpretation of the anti-spiking provision at issue here. And I would just note in particular that while statutory interpretation is the duty of the courts, where the statute is interpreted by the agencies responsible for implementation of that statute and their interpretation is reasonable, this court will not substitute its judgment.
So can I ask you why 25(5) applies to, or doesn't prevent the application of the other provision to Ms. Hartnett?
Yes.
Because it seems like all you've said so far is that they got the other provision right.
The 25(5) does not prevent application to Ms. Hartnett because we go through the analysis and opinion of the justices, and we start with something that is favorable to her, which is we do not disagree that a core of her core expectation she had was that her pension may be based on 3 rather than 5 years, as ultimately was the case here. But that is subject to modification under the reserved police powers. And we would say that the core pieces that come into play are the time that for a pension benefit, which of course a pension benefit is a legal determination, right? Neither the agencies nor the member nor the courts can actually enlarge the benefit that the legislature intended for a member to have. And there we have 3 basic factors. We have the time served, we have the contributions made by the employee, and then we have the public funds that are added. And so we say that there was a very careful analysis done on 25(5)'s application very recently by CRAB, and we commend that decision to the court's attention. That's a Pereira decision, also the Stanton decision, both of which are in my briefing. And when we look at the Pereira decisions, we would start with, as I mentioned, that her expectation of 3 years was interfered with by it needing to go to 5 years. However, we can't stop there. We have to continue. And there we see that In 2008, there was that financial crisis.
Can you interpret the words for us? Because I can't make, the last sentence in particular confuses me. Notwithstanding the previous sentence, if in the 5 years of credible service immediately preceding retirement, the difference in the annual rate of regular compensation between any 2 consecutive years exceeds 100%, the normal yearly amount of retirement shall be based on the average annual rate of compensation received, but during the period, and this is the part that really confuses me, of 5 consecutive years preceding retirement. Was that a drafting error? Should that be the 5 credible years preceding? Is that just, does that make sense?
It would be,
Because doesn't that have to be 5 credible years preceding?
yes, yes.
So that's an error, that's what, that's a problem, right? We have to try to make sense of something that doesn't work.
Not necessarily, Your Honor, because this court has recognized, as the Dalla decision set forth, is that sometimes in statutes, different words are used, but they are deemed synonymous. And there's a nice collection of decisions from this court in the Joint Record Appendix at 133. I'd mention particular the Bulger case and the Mullally case, where this court has not found it to be a problem if different words are used in a statute where it's obvious that they're synonyms.
But
And we
they're
would-
not elsewhere, right? If you read the sentence before it, it's not. They draw a distinction between consecutive. So I just,
So you're in, so in the first, if we may call that the first sentence, it's long, but it's the first sentence, and then the anti-spiking provision we're talking about here we'll call the second sentence. In the first sentence, there is there are 2 different ways that something is going to be determined, right? That's either it's a solid 1 period of time, that's a consecutive period of time, or there's periods of time, plural, where you're putting together credible, credited service
let me
time.
be more specific, though. So they draw a distinction between consecutive. In the previous sentence, they're very clear. Consecutive means consecutive in time, right? They say whether consecutive or not, you know, they're very explicit there, right?
Yes, and so, I'm sorry.
No, go ahead, because I'm
So-
trying to help me make sense of it, because maybe my
Right,
colleagues
so that
understand.
first sentence pre-existed implementation of the anti-spiking provision we have here. But that first sentence was also modified by the same 2011 Act. So it went from 3 years to 5 years through the Section 13 of the 2011 Act. What I would ask you to say is not to get hung up by the first sentence, because what the first sentence means, I think, is pretty well established.
The first sentence is clear. It's the second sentence
Okay.
that's hard, because notwithstanding, if the beginning of the second sentence, if in the 5 years of credible service immediately, the difference in any annual rate of regular between any 2 consecutive years, right? That the previous sentence describes consecutive years as clearly being, you know, sequential in time. But then the last part of the thing says during the period of 5 consecutive years. What if the person doesn't have 5 consecutive years? I mean,
So we're arguing for an interpretation of that second sentence that makes sense. And how it makes sense, because I think you're just suggesting one way that an alternate interpretation would not make sense. So we start with the word notwithstanding. So we know notwithstanding is a significant word. It's saying we're not necessarily jammed up by what happened in the prior. So notwithstanding the previous sentence. And then it talks about if in the 5 years of credible service immediately preceding retirement. We know what those 5 years are, because in order to have a benefit, you need to have 10 years of credible service. So we know what those 5 years are going to be when we're calculating anyone's benefit. And then we say the difference of the annual rate of regular compensation between any 2 consecutive years. Well, that 2 consecutive years, well, it has meaning above in a different context because of the structure of that first sentence. Here, we have to say, okay, notwithstanding the first sentence, and we are talking about 5 years of credible service, immediately, et cetera. So we really have to read 2 consecutive years in light of the language of that particular sentence, and then it plainly applies to Ms. Hartnett.
Can I ask a different question? I want to understand your argument about the police powers exception.
Yes.
And you said that the Superior Court judge didn't do that part of the analysis?
Correct.
Okay, so can you walk us through that?
Yes. And so what I think, I'm not sure how much time I have for that, but let me say that.
No, you can answer the question. You've got time to answer the question for sure.
Thank you. So what I would like to, how I'd like to walk you through that, I think is the best way is to refer you to the Pereira decision. And there we see that there are different reasons that you want to think about whether or not it was a permissible exercise of the police powers. And we would say first, you have to consider that there was the global economic downturn that we discussed, and that was the setting the stage for this particular provision. And then we have the second factor is going to be, well, and obviously that has to do with preserving the pension system, right? Because it's very important to have a fiscally sound pension
Right.
system.
Let me just stop you, because I just want to make sure I understand. Doesn't the whole argument that you're making depend on how many people this would affect?
No.
Why?
So we do not know exactly how many people it affects, and PERAC has said that we're not sure. It doesn't, because we're not talking about we're not talking just about fiscally sound just as in the impact of this one particular decision. We are talking about fiscal impact from the point of view of a variety of factors, which includes uniform application of Chapter 32 across all of the systems, not knowing exactly how many other people are going to come in. We're talking about the contributions that are made by the member, which go to the fiscal, right? Everybody makes contributions, and that's a core part of the system, and we want a system that's free of abuses. And so here you have a situation where this legislation is aimed at more normalizing what the pension is going to be based upon what the contributions from that employee have been, together with the public perception of the system and because the taxpayers matter here too, because the taxpayers do need to fund the system in addition to the employees.
And you think, or your argument is that those considerations should be outweigh 25.5, which says there's a contract between Ms. Hartnett and the Commonwealth.
25.5, as interpreted by this court, it's not a contract in the way that Ms. Hartnett wants it to sound, like, acceptance, performance acceptance, et cetera. It's this court, like in Herrick, has called it, it's a special kind of a thing, and so it is not a breach of a contract for this section to apply to Ms. Hartnett, because she really does not have a core expectation in receiving a pension benefit in an amount that is not commensurate with the amount of contributions. And this is, I want to pause too to say that we are not arguing that on this record that there's anything wrong with how Ms. Hartnett structured her public service. We're talking about the overall good of the system from the financial perspective, as well as the legislative judgment that was made in making this particular provision applicable to her and others. And there I would turn your attention to Section 63 of the 2011 statute, right? There were choices that the legislature made when it enacted this provision, those choices being whether or not the provisions were going to go into effect under the 90-day rule that normally applies, right? Or whether it was under Section 63, it was only going to apply to new members after a certain date. Legislature didn't put this particular provision in either of those categories. Instead, it put it in the category under Section 64 of making it effective April 2nd, 2012. And so it was effective at the time that she retired. In 2006, I don't want to go on.
Yeah, okay, so here's my last question. If we don't agree with you that the reserve police powers exception applies, if we don't agree, then we don't agree with you, right? We would have to rule for Ms. Hartnett.
Yes, we would ask you to be clear that our interpretation of the anti-spiking provision is correct, because there is institutional interest in being sure that that interpretation is nailed down and can be applied, because it is a notoriously complex statute. And if you were to not agree with us on the 25-5 issue, we would ask for guidance and real serious consideration of the Pereira decision and Stanton, but that lays out how CRAB understands what its role is to be when faced with these types of questions. You know, when you have two statutes in tension, where these agencies are charged with interpreting them and applying them.
Okay, thank you.
Thank you.
Okay, Attorney Thomas.
Good morning. May it please the court, my name is Natasha Thomas, and I'm General Counsel for the Boston Retirement Board. And making the best use of the 5 minutes before this court, I would like to focus my presentation mostly on Section 25-5, which would be addressing whether or not the Superior Court incorrectly determined that the anti-spiking statute as applied to Hartnett violated her contractual rights under Section 25-5. This is not a case of first impression. This court has dealt with this in the opinion of the justices in 1973, and they again dealt with it in Madden versus CRAB. And in both of those instances, this court has held that a contract under Section 25-5 is not a contract in the traditional sense. It's more of we have to view it in more of a relaxed version of a contract. And it wouldn't be practical for us to view it as a traditional contract because the pension system is complex. It has various parts.
So
and
what's
it's
the test?
statutory.
I mean, I get it, it's a contract prime, right? It's a different kind of contract.
Yes.
But what is the test for when the state can use its police powers to upset the reasonable expectations of somebody who's retired?
Well, the court provided that answer in Madden. In Madden, the court
Can you
said,
refresh my recollection?
in Madden, the court said that a member who has paid their required contributions cannot be deprived of their benefits. But they also clarified that this does not preclude someone's pension for modification. And it depends on two factors. One, whether or not it's reasonable. And secondly, whether or not there's
The modification is reasonable?
Whether or not the modification is reasonable. And secondly, whether or not the modification bears some relationship to the overall theory of the concept of a pension system and its successful operation.
Does the timing matter when it comes to a particular employee? So in other words, specifically with respect to reasonableness of the modification? So, and I'm only talking about Section 25-5 here. If, for example, the modification had occurred before Ms. Hartnett had left her city employment, would that make a difference for purposes of determining whether the modification was reasonable with respect to her contract expectation or quasi-contract expectation?
Well, the court, in the opinion of the justices and as well as Madden, said that there are some justifications that determine whether or not it's reasonable. And one of them is the financial ability to actually pay the pension system. And in 2011, which is why the board argues that it's reasonable, it's very clear that we suffered a recession in 2008, the Great Recession. The state of Massachusetts was facing $20 billion in unfunded pension liability. And so the legislature decided to enact pension reform in order to preserve the system. Some states didn't, and they no longer have a pension system, but our legislature took certain acts, and one of them being the anti-spiking statute, in order to reduce the liability because they weren't being funded.
So I take it you're not saying that Ms. Hartnett did not have an expectation that qualified for protection under 25.5. What you're saying is that was then overridden by these countervailing considerations that justified making this particular amendment.
Yes, that's exactly what I'm saying. In Madden, we kind of have a similar situation, which I think the court can apply the same analysis and the same reasoning. In Madden, the Teachers Retirement Board did not have any authority or law or regulation really discussing part-time or full-time work. And so teachers tended to work part-time, and then the last 3 years of their employment, they would work full-time. And so they received full credible service, although they hadn't worked full-time and hadn't contributed what a full-time employee would pay. And so Madden was working part-time, and then she subsequently worked full-time. And in 1990, she began working before 1990. In 1990, the TRB, the Teachers Retirement Board, created a regulation which essentially prorated their part-time work. And so here the court said that as it relates to Madden, we could apply it prospectively, but not retroactively. And the reason why it was found reasonable is because TRB had an interest in protecting the viability of the pension system. Here we have teachers who were benefiting, and it didn't matter if they didn't have any nefarious intent, but they were benefiting because they were able to work part-time their whole career. In the last 3 years, which was full-time work with a higher salary, and then get credible service. But then you had teachers who had worked full-time their entire careers, and they had contributed based on that full-time work, and you had teachers who hadn't, and they were receiving that same pension.
So in that case, the teacher did not, the rule did apply, the new rule did apply to the member?
It applied prospectively. So any future work that she did part-time, her part-time work from 1990 on, because she was still employed at the time, was prorated, and anything before there was any rules or laws, actually a law regulating that part-time work, she received full-time credit for it.
Now, she was given inaccurate advice, right? Did she retire based on the inaccurate advice? And does that figure into the 25.5 analysis?
It doesn't. I don't believe that it figures into the 25.5 analysis because under the general laws, Chapter 32 has a section 20, subsection 5, C2, boards are required to correct an error. So if you find an error and someone is receiving a greater benefit than they're entitled to, the board must recoup that, statutorily required to do so.
But does that figure into the expectation analysis? If you actually talk to the right pension people and they tell you we're going to do it one way, and then you go retire, doesn't that figure into the 25.5 analysis, that you got the wrong guidance from the agency that's supposed to give you guidance?
The appeals court addressed this issue in Cloister, and that also was the Teachers Retirement Board, and it was a teacher who had actually relied on incorrect information. He sold his home, he moved to Florida, and then the pension system eventually determined that he was not entitled to time that he had actually purchased back, and the court held that under 20 subsection 5C2, the board was statutorily required to correct that error. So they had an expectation, but an error occurred, and that took precedent.
And that was us, or that was the appeals court?
That was the appeals
Do you
court.
think the expectation is measured at the date when Hartnett decided to leave her employment, the date when she decided to apply for a pension, or some other date?
The expectation is actually the date that they entered the system, the date they began employment, because analysis, I believe that Madden also answered that question and why this is parallel. Because in the case before the court, Hartnett did enter the system before the anti-spiking statute. But the similarity is that there was no section of Chapter 32 that dealt with an employee who had doubled their salary before retiring.
So entering the system in this case is the date she comes and works for the city?
The city, because she refunded from the state, so she no longer has that as the start of her membership date. So when she started, there was no section of Chapter 32 that dealt with a huge spike in your pay right before you retire. So the statute
Rule is that you have contractual expectations, prime, subject to the economic ability of the state to pay the pension.
yes, which
That's the test for Section 5, that
Yes.
or 25.5.
yes,
Okay, thank you.
yes, and so
Make sure I understand. I didn't read Madden, but are you saying that they're in the same position, that Madden and Hartnett would be in the same position?
yes, that's my position, that they're in the same position, because when she entered the system, there was no law or legal authority that dictated what happens if your pension exceeds over 100%, right? Because it's based on your last three. So if you're making 34 and then you end service with 100,000, what happens? And so the legislature created this in order to kind of preserve funding, preserve the money into the system, and lessen.
But it doesn't affect Hartnett because she had an expectation.
She did have an expectation, but the statute, because she didn't retire before the effective date, it would apply to her. So similar to Madden, the teacher, her past service was not prorated, but she stayed in the system and she worked full-time. So any future work, they would prorate her part-time work. So it's similar here. Those who had already retired or who retired before the effective date, they spiked, they were able to retire. And we didn't go back and have to recalculate anyone's pension. But effective April 2nd, 2012, anyone who retired at that date or after came under the umbrella of the anti-spiking statute.
So she had retired in the sense that she had stopped working.
She had stopped working for the public employer.
Right.
But not
she had not made a claim yet for her pension.
correct.
So is that what you're calling retirement? Because she retired before the amendment came into play.
She did not
was-
retire before the amendment.
I mean, she left employment in 2006.
She left employment in 2006.
Then the anti-spiking provision was enacted in 2011.
Yes,
And then she makes her application for retirement benefits in 2016, if I have the chronology correct.
yes, that is correct. So she left her money in the system and she deferred her retirement, which you can do. You can leave your money in the system. She had the age to retire before the effective date, but she chose not to.
So that was her mistake.
Yes.
Okay, so if she had taken her money out, she would have not had to have dealt with the anti-spike.
Right, if she had retired before the effective
Meaning
date.
making a claim. Retired meaning making a claim. And
Yes, retired
starting her-
meeting, filing an intent to retire and receiving her superannuation monthly.
Okay.
And so, based on Madden and based on this court's interpretation of the contract and its position that the contract is not a contract in the strict sense, but it protects a member of the core of their reasonable expectations, I would also argue that Hartnett has received, she hasn't been deprived of the core of her reasonable expectations. So she had public service with the state. It was $34,000. She left with the city and it was $100,000. And so the anti-spiking statute did apply to her, but she still has a large pension that's not reflective of her prior service in the public, which was the intent of the legislature. They created this statute, and the section does not have any exceptions. It doesn't look into the subjective state of the person's mind. It just focuses on the fact that your pension, that your salary doubled or increased over 100% before you retired. And the goal of the legislature was to kind of get rid of those loopholes and create a structure where we have people who are contributing and their pension is reflective of their salary while they provided that.
Okay, thank you. All right, Attorney McDonough.
Good morning. Sorry. Good morning, Madam Chief Justice and members of the court. May it please the court. I'm Gerald McDonough. I represent the plaintiff appellee here, Susan Hartnett, and I'm here with my co-counsel, Thomas Gibson. I first want to make clear, unless there are any questions to start off with, based on the arguments from my sister counsel over here, I just want to start off by acknowledging what this is not about. This is not a challenge to the legislator's authority to do any kind of change in the system whatsoever. And we believe that we do not dispute the claim that this was a difficult time back in 2010 and 11, difficult time where there was a financial crisis, and there was a need to really address some long-standing abuses. And I mean abuses in the public pension system. And when you look at Pereira decision in Stanton, they were dealing with that year-for-a-day provision, where an elected official who worked one day in a calendar year could get credible service for the entire year. And that had long been characterized as an egregious abuse of the pension system. In contrast, with breaks in service, there's no evidence anywhere that that was on the mind of anyone at the time. For example, there was a commission set up in 2009 to look at pension reform, and they came up with a whole lot of different aspects of reforms that could be made in the pension system. And one of those was expanding the years of credible service for retirement from 3 years to 5 years. Another one, which was in Section 13 of Chapter 176, which is the last part of the first sentence of Section 52A now. The other one that they looked at was what became Section 18 of Chapter 176, which is now 52F of Chapter 32, which deals with that 10% increase in any between 2 consecutive years of service, that anti-spiking provision. There was nothing in there about breaks in service. And then we had I just want to make sure, you agree with the Superior Court's ruling, right? I agree with the Superior Court's ruling with regard to 25.5, Your Honor, finding that it does not, that this statute, if it's interpreted to cover breaks in service, which we do not agree with, we agree that part of the decision we agree with.
Can you give me an example of prohibited anti-spiking?
Excuse me?
Can you give me an example of prohibited anti-spiking under your definition?
Well, the anti-spiking in Section 18 of Chapter 176, which is now Section 52F of Chapter 32, deals with if any of the years that your retirement is calculated, you take the average of 2 years before one of those years, and if the increase goes up more than 10%, anything that goes beyond 10% won't be included in the calculation of your retirement. And that was what the Commission in 2009 recommended. That was one of the elements of pension reform that Jim Lomenzo, who was the actuary for PERAC at the time, did a whole report, a cost analysis, and he looked at that and determined, well, it's not going to be a lot, but it would be a good idea to do it, so I support it. And then there was a final report by the Pension Commission, which came out, and again, only addressed 2 things: increasing 3 years to 5 years for the span of time for calculating retirement, and the other provision that's now in 52F about the 10% increase. And not only in that next commission report in 2011, they actually looked at all the other states and what they were doing in terms of anti-spiking legislation. There's not a single mention of an issue like Section 14 is being characterized as dealing with breaks in service. It's not mentioned in any of those
Counsel,
states.
let me ask you a question then, because I'm trying to figure out what the limiting principle would be if we follow your logic. So Ms. Hartnett stops working for the city of Boston in 2006. And there's no question that when she came to work for the city, she bought back the service that she had from before when she left the first time around for the state.
That's correct.
So she applies for retirement benefits in 2011, right?
No, she applied for benefits in 2016.
But in 2000, if we were looking at the way you're characterizing it, how would that make sense under our canons of statutory construction, because if it were not read the way that the Superior Court judge was interpreting it, to read consecutive and not contiguous, could it necessarily subsume work that wasn't for a credible employer?
I'm not sure I understand your question, Your Honor, but
You're saying it doesn't, you can't look at breaks, right? In calculating the whether it's 3 years or 5 years. You're saying it's got to be contiguous, right?
according to Section 14, yes.
Well, according to your interpretation, that's what we're here to figure out. But if it's not, if you don't read it the way the Superior Court judge interpreted it, couldn't you have a situation where the 3 years or the 5 included work and salary for an employer that wasn't part of the state retirement system?
Yes.
So how would that make sense?
Well,
Or
Your Honor,
why would that make sense?
Your Honor, there are a number of instances where Section 14 would apply and affect employees that aren't addressed in anywhere in the record here so far. Someone could leave a position with the state and go work for another entity in the state, like go work for Mass Development, which does not have not part of the contributory retirement system, and then go back and move again to state service in another position. Someone in this case could, if you read this thing the way it is written, someone could leave work for a variety of different, people leave work for a variety of different reasons. A lot of people will leave work because they have childcare responsibilities. Costs for childcare are prohibitive in terms of, paying for childcare and getting a job and whatnot, or taking care of sick relatives. There are a whole variety of reasons why people leave state service and then come back. The real question is, did the legislature intend, in addition to other things, did they intend for people who were taking legitimate breaks like that were they trying to change the retirement law for them?
But don't we look to what you're asking us to look to, which is an absence of explicit legislative consideration? Don't we look to that only if the language of the statute is ambiguous? If the language of the statute is plain, then we, I believe, take that as the expressed intention of the legislature, and we don't go looking beyond it, correct?
Yes.
All right, so I guess the first step of your argument is Section 14 is ambiguous,
Yes.
and therefore we need to look to other indications of legislative intent, including the absence of explicit consideration by the legislature?
Yes.
Okay.
Your Honor, simply by including 4 words in Section 14 that appear twice in the language above, whether or not consistent, simply applying that into Section 14 would have made it quite clear that it was intended to deal with breaks in service, but that's not what we see in the language at all. And if you look at the language, consider this, if you will. If you look at the language, it says, notwithstanding the sentence immediately preceding. If you look at the sentence immediately preceding, which talks about going from 3 years to 5 years for anyone who's hired after April of 2012, if you read that consistently, you would have a person who would work for, say, for example, $100,000 salary for 20 years, then leave state service, try to do some other things. And one of the things might be, maybe I'll serve on a school committee or city council, as was the case in the Julia Hearn case with her husband. And what if in those 5 years of work and it's pensionable, what if in those 5 years of service, in the last year the stipend went up from $5,000 a year to $15,000 a year? You would then have to calculate that person's retirement, not on the highest years of credible service, but on the last 5 years of credible service. It would go from an average of $100,000 a year to an average of $7,000 a year. That, if you want to read the language in Section 14 and what it would apply to, that would certainly be one thing it would apply to.
So,
Where is the ambiguity exactly in the sentence, that last sentence? Is it in the the end of it, where they talk about 5 consecutive years of preceding retirement, where do you see the ambiguity? Because
I see the ambiguity all through the
But can you be more particular?
There's-
Which word? I mean, notwithstanding
Well,
seems
there's-
pretty
There's the
clear.
inclusion of the word consecutive there, which has to have a meaning, for number one.
I thought that, I thought the last statement of consecutive got confusing because during the period of 5 consecutive years preceding, because there might not be 5 consecutive years, right, preceding retirement. That to me seemed ambiguous. And
As
that's
was the case with Susan Hartnett. She did not have 5 consecutive years
right.
preceding
So
retirement.
that to me lends support to your view that it's ambiguous. You think the Superior Court judge misinterpreted this, the first part. You like her second
Yes.
part of her decision. You don't like her first part of her decision.
That is correct.
And
Your Honor.
Crab, I can't remember, they're arguing what on the first sentence? They think she got it right. I think they think that she got it right.
Your Honor, CRAB isn't, as an agency, is entitled to a lot of deference because of its expertise, knowledge, and competence. But in this case, if what CRAB did exhibits that, I don't know what it means anymore. I mean, CRAB initially, when they were forced with this, when we filed our objections with CRAB, CRAB came back and said, well, you're right about, the definition of consecutive in the first sentence of 528, but that was, and it is in the same section of the statute, but that was enacted at a different time. So we filed a motion for reconsideration, and we pointed out to CRAB that even though it was, that might be accurate, there was an immediately preceding sentence, section 13 of chapter 170.
So they're entitled to change their position.
Right.
I guess, my question is why do you see the ambiguity, along Justice Kafker's question, where is that ambiguity in that last sentence?
I think, Your Honor, I think
It's in the consecutive years?
I think
The first time it's used, the second time it's used, where is that?
both times the consecutive is used. What is the purpose of consecutive there? Why did they put consecutive in there?
It
The other
seems to me it's
ambiguity.
all, I'm sorry, I may be misreading this. I understand there to be a conditional clause that begins with the word if. Do you see that? It
Yes.
says, if in the 5 years of credible service immediately preceding retirement, the difference in the annual rate of regular compensation between any 2 consecutive years, which I assume to be a reference to within the 5 years of credible service, exceeds 100%. That's an initial conditional clause that then is followed by something that will happen if you're within that first conditional clause. I don't understand where the ambiguity could be, except perhaps in the language that then refers to the period of 5 consecutive years preceding retirement.
That is an ambiguity, as well as the use of the word immediately with the first clause there. It doesn't say in the 5 years of credible service preceding retirement. It says in the 5 years of credible service immediately preceding retirement. Either that word is put in there to mean something or not mean something.
So
Why is that ambiguous?
Right.
Excuse me?
I don't understand how that is ambiguous.
Well,
It's
it
the
isn't
5
ambiguous- it
years
isn't
of credible
ambiguous-
service right before retirement.
It isn't ambiguous to me, Your Honor, but it's been interpreted a different way by the appellants in this case, so I think that creates ambiguity.
Well, just because it's their interpretation, the words are plain.
Well, the words are plain. 5 years of credible service immediately preceding retirement
Right.
would be 5 years immediately before retirement.
No, of the credible service.
Credible
years.
Credible
service.
service.
Yeah, immediately preceding retirement.
Right, so that would include the gap.
I don't think it should, Your Honor.
Well, you don't think it should, but the words say, right?
Yes?
It says credible service immediately preceding retirement. So it would subsume the 3 years with the city, and then the gap, and then going all the way back to the state service.
And then it goes on to say received by the member during the period of 5 consecutive years.
Right.
Preceding retirement.
See, if that had, everything, you like everything up till that last part, right? Because it would preclude punishing your client for that increase during that break. It's just if the last word were 5 credible years of preceding retirement, if the last sentence ended with 5 credible years, there's no ambiguity whatsoever in this thing, is
Or
there?
if they had simply added in notwithstanding, what's that phrase there, those 4 words?
Whether or not consecutive.
Whether consecutive or not. Right. I mean, if that were in there, that would make it clear. Let me move on to.
Do you agree with the position of the appellants that retirement for these purposes is the date on which the participant has applied for the retirement benefits?
No, I don't, Your Honor. I believe you're able to postpone your retirement as long as you want. The statutes, the
So
court
what
case-
would be the meaning of retirement as used here? Is there a statutory definition of the word retirement?
Well, you don't retire actually until you file a retirement application.
That's what they said. Okay.
Yes.
Counsel, can I ask you a slightly different question? Assume for the sake of argument that, again, you win on the interpretation. But let's say that of whether it's consecutive, credible, that first part. But on the 25, if we go through the analysis and do the second part of and I think you might agree that Judge Cowan did not do the second part of the 25 analysis. Assume we do the second part of the 25 analysis and whether or not there is a reasonable basis for the interruption of the claimant's retirement expectation, you could still lose.
I don't think so, Your Honor. Let me explain. First off, Judge Cowan did not do that analysis because nothing was presented to the judge by Crabb regarding that. They decided not to argue that issue at all. That issue only came up when they drafted a brief for the appeals court. So there's a brand new argument that we're hearing about in terms of the police powers. Secondly, Your Honor, the police powers are...
Isn't the police power issue in the case law?
Yes.
It says that, right? So that's the test.
Yes.
She only went through one part of the test.
Yes, Your Honor, but but I think that the police powers here is really too extensive to take an issue like this for which there's no knowledge about any egregious behavior by anyone, by no cost analysis as to what the cost of this would be, no evidence as to how many people this would affect. I mean, it seriously affects my client. It may seriously affect some other people who have breaks in service, but we have no idea what that is, and the language itself is so unclear. To say that this language it was designed to deal expressly with breaks in service when there are other reasons it could be applied. Somebody could work for a while, a long career of work, and then the last 3 years they get a big job at an authority or someplace else, and their salary goes up. Perfect placement for this Section 14. So we're not saying Section 14 should go away. We're saying it doesn't apply to a client, doesn't apply to breaks in service.
Before you leave, I'm concerned about the inequity to your client, that she was misled by the people who were advising her on the pension fund. Do you want to address this appeals court decision where supposedly that's okay?
Your Honor, I work in public service. I understand that people in public service make mistakes and you can overlook those. This goes to her reasonable expectations.
Just the case. Is the case distinguishable or not, or is the case right on all fours?
I think it's distinguishable,
the
Your Honor.
case.
Not only that, Your Honor, in this particular case, she went to work with this understanding as to what her benefits would be if she lasted 2 years, because you have to last 2 years when you go back to work.
Mm-hmm.
She believed that during the course of her employment. She believed that when she left her employment with the city. She went for counseling in the city. City of Boston Retirement Board never mentioned this to her and it's not a mistake, Your Honor. City of Boston never mentioned to her when she went to retire. They never mentioned it when they calculated her retirement, and they went back and calculated her retirement a second time. A second time they went and looked at her retirement to make sure it was right, and they adjusted it up a little bit. It was only years later, a year after, months after her retirement, but years after the law went into effect.
I get the
Boston
equities.
Board.
Just trying to get you to distinguish the case for us. How do we distinguish this appeals court case?
The Boston Board completely agreed with our interpretation of the statute until 2017. The law went into effect in 2012, And the Boston board agreed with our position up until the time that Ms. Hartnett went to retire.
Okay,
If there are
thank
no
you.
further questions,